Mr. MacCormick, please, for 1 minute.
Mr. President, my remarks will concern security aspects of today's debate. Members of the House may not be aware of an ill-judged intervention into national politics by the Secretary-General of NATO today. Lord Robertson just recently attacked as isolationist the Scottish National Party's policy concerning NATO membership. That policy, I should tell you, is equivalent in effect to the stance of Austria, Finland and Sweden, and also Ireland, though the occasion of Lord Robertson's intervention was Ireland's accession to the Partnership for Peace programme. I do hope that the President in Office of Council will deplore, as I do, a party political intervention by the Secretary-General of NATO, the logical implication of which is an attack on the defence policy of Finland and other member states. For the record, I should like to make it clear that, in common with all our colleagues in the Greens European Free Alliance, we in the SNP are committed to the idea of collective security in Europe and welcome developments the Council will pursue to this end. But we are rootedly opposed to the maintenance of nuclear weapons in Scottish coastal waters or coastal waters anywhere in Europe or the land of Europe. This is a determining factor for defence policy as far as we are concerned, and I don't for a moment imagine that Ireland is in the process of developing a policy aimed at giving hospitality to nuclear weapons in their waters. Indeed, Mr. Collins assured me that this has nothing to do with NATO membership. I hope that in developing our crisis management policy, we in Europe will think carefully where, if anywhere, nuclear weapons belong in it. I don't think they belong at all.
Thank you very much, Mr. MacCormick. I understood very clearly what you were saying. Now, Mr. Senyi, please, for 2 minutes. I don't think Mr.
Ik geef allereerst het woord aan de heer MacCormick als voorstander van het voorstel
who wants to speak
voor
in
de tijd van
favour
1
of the
minuut.
motion for 1 minute.
Thank you very much, President. As Mr. Hudghton said, and as members of the House will recall, I rose on Monday to say that I thought that an element in this report is inadmissible because lacking in a legal basis. This, of course, is rather a doomsday weapon, and I would be unhappy if we had to use it where there is a simpler method available to us to reconsider the question before it finally comes back to the House. It is a very important point. Paragraph 6 of the QMUL report, as I read it, and as many of my colleagues read it, effectively proposes undercutting the principle of relative stability, which has since 1983 been the very foundation of the common fisheries policy, and which indeed Commissioner Fischler, at his hearing before this House, said to be foundational to the common fisheries policy. Introduction of a scheme of quota penalties would undercut it badly, and that is what paragraph 6 suggests. That should be taken back, and it should be thought about in committee, both in the Fisheries Committee and in the Legal Affairs Committee, and I have pleasure in asking the House to support Mr. Hudghton's motion.
Dank u wel. U steunde het ordevoorstel.
Thank you. So you've spoken in
geef ik nu het
favour
woord aan
of
mevrouw
the Hudghton's
Fraga
motion. Now I'll give the floor.
Ik zie... Of de orde? Oh, ja. Ik zie de heer MacCormick.
Mr. MacCormick.
Meneer MacCormick,
Mr. MacCormick.
gaat het over de orde?
Do you want to make a point of order?
Het woord is aan de heer MacCormick.
Mr. MacCormick.
I request therefore now, President, to move the inadmissibility of paragraph 6 of the QMUL report.
Meneer MacCormick.
Mr. MacCormick.
U brengt naar voren de niet ontvankelijkheid.
You say you want to move the inadmissibility of this paragraph. Is that a formal point of order? Could you perhaps cite the relevant rule of procedure, if so?
President, Rule 143(1). At the beginning of the debate on a specific item on the agenda, its inadmissibility may be moved. Such a motion shall be put to the vote immediately. I move that it is inadmissible and request that you put it to the vote immediately. I was deeply unimpressed with the arguments I earlier heard.
Ja, Meneer MacCormick,
Mr. MacCormick,
de regel die we net hebben
here again, the same rule applies, which is that we have a speaker in favour of that motion and a speaker against. Could I ask if there's a speaker in favour of this motion under Rule 143, moving the inadmissibility of a matter?
Van dit rapport. Ik zie de heer Hodgson,
Mr. Hodgson
voor dit ordevoorstel
wants to speak in favour
de
of
heer Hodgson.
the motion on inadmissibility. Mr. Hodgson, please.
Yes, President, I have great pleasure in supporting my colleague's motion of inadmissibility. The inadmissibility of paragraph 6 of the report, I must emphasise, paragraph 6. And I believe that there is sufficient doubt about the legal applicability of the proposal there in terms of automatic quota reductions that we ought to be declaring and ruling that this paragraph, not the rest of the report, paragraph 6, is inadmissible. Thank you.
Dank u wel. Is er ook iemand tegen
Thank you. Is there anyone who wants to speak against the motion under Rule 143?
Ja.
Mr. MacCormick, please.
I was very glad to learn last week that the Commission is giving close attention over a number of years to the concept of subsidiarity and its reference not merely to relations between the Union and Member States, but also the Union, the Member States and regions and indeed cities. I hope that in his pursuit of dialogue around the regions of Europe, Mr. Barnier will expand upon that thought and learn from what he hears.
Very brief. Thank you very much, Mr. MacCormick. Mr. Berthu, please. Thank you, Mr. Napolitano. Mr. MacCormick, please. 1.5 minutes.
Thank you, President. I should like to express my substantial agreement with the point just made by Mr. Napolitano. It is, when you think of it, odd to suppose that a great set of institutions of this kind could be thought capable of existing without some constitution, and manifestly we do exist, and therefore manifestly we already have some kind of a constitution. The question is, do we have an adequate constitution, and what kind of constitution do we want? To say we need a constitution is not to say that the kind of constitution the European Union should have is the constitution of a state, for the Union is not a state and is not about to become one. It is therefore, of course, a good thing, and we all agree on this, that there should be proper recognition of rights within the Union, and that the rights should bind the organs and institutions of the Union. Far too much power is exercisable by Union organs and institutions for it to be safe to permit them that power without the proper control which a Charter of Rights would imply. So that seems another clear point. There is, in my judgment, one risk, however. One of the great success stories of Europe is the way in which the European Court of Justice, especially when other institutions were blocked, succeeded in building the concept of Europe as a community under law. If we create a Charter of Rights that overloads the Court of Justice, that has everybody beating a path every week to Strasbourg, and, I beg your pardon, to Luxembourg, we will destroy the purpose. We must ensure that the main avenue for protecting rights is in the national courts, and that a supervisory jurisdiction is exercised at European level. If we don't succeed in that, we will fail in all.
Thank you very much. Now, Mrs. Fram, please.
Institutional architecture.
Tem a palavra. Sr. Deputado MacCormick.
The next speaker is Mr. MacCormick for 1.5 minutes.
Tem a palavra, Sr. Deputado MacCormick.
We, for our part, of course, welcome the enlargement of Europe and will participate in the discussion of how to prepare for it. The Scottish National Party, which I represent in its manifesto and its general policy, is committed to the idea of Europe as a confederation of peoples, countries and regions, not a sovereign federal union in its own right. That is something which the parties of the European Free Alliance all have in common, and our votes will be cast in that light. I want to draw attention particularly to Amendment 138 in its interaction with paragraph 3.2 of the Dimitriakopoulos Leinen report, with its proposal for all Europe lists of candidates. We in Scotland, as a small nation within a large member state, are seriously concerned about the practical disappearance of Scotland as a distinct entity within this union, and the same would go for Euskadi, Flanders, Galicia, Andalusia and Wales. The reduction of members of the European Parliament that we would face, coupled with the arrival of new member states, smaller in population than Scotland or Wales, but fully represented on all the institutions of the Union, will certainly increase the pressure for and our people's commitment to the idea of our own independence in this great European confederation.
Chers collègues, le débat est interrompu. Nous le reprendrons à 15
we are
heures.
going
Je vous invite
to
à regagner
interrupt
votre
this
siège car nous allons
debate and
procéder à
resume
une
at
séance
3.
de
Could we
vote.
all find our seats, please, and we can make a start to the voting.
L'ordre du jour appelle le vote de 5
The next
propositions de
item on the
résolution
agenda
sur
is
le
the vote on
principe
5 motions for
d'additionnalité.
resolutions.
Thank you, Mr. MacCormick.
President, I'm grateful to Commissioner Liikanen for, if I may say so, a characteristically thorough answer to each of the points which I raised in my question, and I'm grateful for the assurances about communication with the industry as well as with governments, and I think that is very important. I would just like to underline, however, that although this is and is rightly looked at as an issue about the spirits industry in the community as a whole, the fact is, as we all know, that by far the major exporter is the Scotch whisky industry. Commissioner Liikanen will be well aware that the production, particularly of malt whisky for export, is concentrated in the peripheral parts of Scotland, in the islands and in the glens of Strathspey and in other remote parts. These parts are suffering very heavily for a variety of reasons, agriculturally and in other ways at the moment. I don't suppose that it's the intention of the Commission to make life impossible in these places, but a combination of measures might well have that effect by accident, and I ask him to direct his attention to that.
Muchas gracias, señor MacCormick. Tiene la palabra.
Thank you, Professor MacCormick. Mr.
Both for us and for Derek Rockabanabe.
For 1 minute, give the floor to Mr. MacCormick.
Thank you, President. The United States, we recall, is the country of the world which has had for the longest time an entrenched and justiciable Bill of Rights. It is therefore a horrible irony that the United States is one of the few countries in the developed world which still retains and practices the use of the death penalty. We face today a particular case, that of Derek Rocco Barnaby, and each human being is an individual in her or his own right and must be stood up for as such. And we appeal for his life today. But he is also, as well, a symbol of a practice which we find appalling and which we know to be growing in many parts of the United States. I am myself a great lover of the United States and many aspects of its way of life. I've been a frequent visitor to the law school of the University of Texas and to other law schools in the United States, and I admire them very much. But I'm really sad to see that state and its governor practicing this so frequently and boasting of it in presidential campaigns.
Thank you, Mr. MacCormick. And I now give the floor to the last speaker, Mr. Vattimo, for 1 minute.
Grazie, signor Presidente. La urgenza della nostra risoluzione.
come to a vote on 3 motions for resolution on hooliganism. Mr. MacCormick.
President, I'd just like to draw attention to an error in translation in some of the texts. The English language text says at clause 6, asks the British government to consider sharing the cost of transporting English hooligans back home by Belgian C-130 planes. And that correctly differentiates the whole from one of its parts in a context in which the 4 component parts of the United Kingdom each field national football teams in these competitions. Therefore, it is important. I raised this point on Monday, and I'm glad to say that all but 3 of the language versions are correct. Unfortunately, however, in the Spanish, the Danish, and the Italian, the word British, or its equivalent, is repeated, where the second word should be respectively Engelske and Inglesis and Inglesi.
Thank you. Thank you, Mr. MacCormick. The English text is the original text, and the others will be so adapted.
And effective. Thank you.
Thank you, Mr. Bison. I now call Mr. MacCormick for 5 minutes representing the Green European Free Alliance Group.
Thank you, President. It is a great pleasure to have the opportunity of commenting on this report of Mr. Vuurmeling's and on the fundamental underlying question of making our law in Europe good law and clear law. And I congratulate Mr. Vuurmeling on his report. Etienne Dumont and his great English master, Jeremy Bentham, were inclined to make the point that since laws are always in some measure coercive, they are always in some measure evil. But they may be necessary evils where they control yet greater evil, but they should only do so. And they should only do so proportionately to the evil to be met and dealt with. We, I think, can accept this point. And this report, I think, is in that spirit, in demanding clarity of law, simplicity of law, and proportionality of the legal means to the end sought, the public end sought. In addition, and vitally, the report raises the issue of subsidiarity, and this is in some measure controversial in this chamber tonight. Subsidiarity, indeed, comes from the work of Pope Pius IX, and therefore from an enemy of the Benthamite approach to law. But on this thing, I think 2 different traditions of thought would come together. It is not a good thing to take decision-making away from the most local level at which it can be efficiently exercised, whether that be the level of the individual, the family, the village, the town, or whatever. I receive letters from time to time, one only last week, from a constituent of mine living in a remote part of the West Highlands of Scotland. He said to me, "What are you people out there doing? For 2,000 years or more, people have been safely drinking the water from the burns, the little rivers of the Highlands, and now they are prohibited from doing so, and elaborate schemes of water purification are imposed upon them to no public good." I hear similar things from residents of the island of Islay, where the proposal to produce protection of the local seal colony by a grand international body is resented because the people have looked after the seals better for the last 2,000 years than we think the grander organisation is likely to do in the future. The point is made. Law should be made close to the people, and local knowledge, whenever it is the most relevant knowledge, should always be applied rather than the grand overarching scheme. It is, however, of course, also true that there are some public goods that can be pursued only at the most general level, and there are indeed aspects of environment protection, aspects of species protection, for example, aspects also of single market law, aspects of law against protection, aspects of law to govern the internet, which can only be done at least as generally as at European level. The principle of subsidiarity, properly understood, points us in both directions. Take decisions at the lowest level possible, but acknowledge that the lowest level possible may be indeed a very high level where general goods are at stake that will be lost unless protected on the same terms everywhere. So that, I think, does make this stress upon subsidiarity very important. I do think that my friend Mr. Medina and his colleagues are wrong in saying that this is only a political principle. It's a constitutional principle. And like all constitutional principles, it has on the one side a political impact when we, the legislator, decide what law to make. But it has on the other hand a legal impact when it comes to the question, how should the courts interpret and apply the law? May I finally commend to the House Amendment number 1, which asks that the Commission and the Union take seriously the fact that we have, as well as the Union and the States, autonomous self-governing communities within. I represent Scotland in this House. Scotland and England formed the United Kingdom by treaty in 1707 and have maintained it since then. For 290 years, however, Scots law, which remained a distinct body of law midway between the civil law of continental Europe and the common law of England and the Americas, Scots law retained a distinct system but was legislated only from Westminster. We have now created a Scottish Parliament in the last year. Scots private law has been sent back home. Scots criminal law has been sent back home. It would be an irony indeed if at the very moment of achieving that we were to transfer the whole of legislative power over private and criminal and commercial law to the Union. And I don't think that's what is intended or will happen. But it is important to bear in mind the interests of subsidiarity, the interests of this at levels below the Member States, as well as between the Member States and the Union, and there is no reason at all why the constitutional principle that is at stake cannot be interpreted widely and generously at all levels of this great Union.
Merci, Professeur MacCormick. La parole est maintenant à Madame Mathieu, au nom du groupe pour l'Europe des démocraties et des différences, pour 2 minutes.
Point as far as we're concerned.
Senor MacCormick.
Thank you, Mr. MacCormick.
It's a great privilege, President, to take part in this important debate. I'm a bit sad that some part of the tone of the debate has been negative and guarded. We do need to remember that new media of communication have in fact liberated interaction between people and ideas and between people and people. Of course, that does give rise to some reasonable concerns about the protection of legitimate copyright interests in this age. But meeting these concerns must not result in obstructing the ordinary person, the scholar or the scientist accessing and using materials that are subject to copyright. The balance between the producer interest and the consumer interest is, as has been well said in this debate, the balance we have to try and strike. If we in the Union were to strike the wrong balance, it would seriously inhibit the democratic openness of discussion that the Internet and related media facilitate. Again, if, for example, unreasonable restraints are placed on libraries, students, scholars and scientists will be the sufferers. The interlibrary loan scheme might become a casualty, an accidental casualty of change. The draft directive before us writes in, critically at section 5.5, the well-established restraints on fair dealing that are enshrined in the Berne Convention. Subject to these, but only subject to these, Member States will be enabled to create regulated limits on copyright interests for the benefit of disabled people, private consumers, public libraries and museums, and some others. But that is permissive. Member States will be able to do it, not, in any case, required to do it. And that will be a matter for local judgment guided by subsidiarity. As an author myself, I yield to nobody in maintaining the rights of authors and performers, I add performers deliberately, to fair recognition and reward. But these values will be misapplied if they are used as the ground for obstructing reasonable limitations on commercial copyright interests. And I stress the commercial interests which we need to differentiate from the moral right of the author, which is expressly excluded from this directive. Like others, I am delighted with Mr. Boselli's work, and I hope that we will pass this with relatively small change.
Thank you, Mr. McCormick. Now for 1 minute, Mr. Alavanos.
Thank you, President. I shall speak with a voice which has not been much heard in this debate so far, despite two words in Mr. Barnier's speech about regional parliaments. It must be remembered that Europe is not just a Europe of central institutions and member states, but that within the member states there are self-governing bodies, self-governing countries, called in the parlance of this House, of course, regions, but many of the citizens of these countries regard themselves as the citizens of ancient European nations, deserving recognition in this union as much as others. Mr. Pöttering rightly said that the community method is a good method from the point of view of small states. Let it be also a good method for the members of small countries that are not, or not yet, states of this union as such. If, in the debate which takes place in the next 3 years, the voice of the democratically elected parliaments of the countries and regions of Europe within the member states are not heard properly and not taken as fully into account as the voices of the member states themselves, of the national parliaments, and indeed, and rightly said by Mrs. Frassoni, of the NGOs, then the debate will have been a failure. In its logic, subsidiarity is a two-ended concept. At one end, it says, let all decisions be taken as close to the people affected as can be done consistently with efficiency and equity. But that implies, of course, that there are many decisions that can only be taken at the other end, at the high end, where for equity and efficiency, the whole of a great polity must be included. But that great polity will not do well if it doesn't seek always to ensure that it avoids taking power from the little people, from the little battalions, from the lower levels of government. We must have a proper representation of the regions of Europe in this discussion and a proper attention to subsidiarity.
Herr Sjöstedt für eine Minute.
Sjöstedt for 1 minute.
Thank you, President.
Thank you very much. Mr. MacCormick for 1 minute.
Thank you, President. I would like to express my agreement with Mr. Katiforis. This is a really bad case, I think, of an unjustifiable seizure of a person outside the territory to which he was then taken and in which he has been illegally detained since that time, which is already some months ago, December the 13th. We do want to take account of the fact, do we not, that Turkey has been advanced towards candidate status for membership of the Union, and that so long as we have sores of this kind weeping in the corner of the Mediterranean and problems of this sort, Turkey puts itself outside of reasonable consideration. This is a grievous attack on human rights. It's an insult to a human being of a totally unacceptable kind, and we call for the President to let us put this resolution forward with the support of the whole of Parliament.
Thank you very much. Now I give the floor to Mr. Alison Drakis for 1 minute.
Ευχαριστώ, κύριε Πρόεδρε. Οι κατηγορίες
Thank you. That was the sub-item Ethiopia, and now we come to the debate on human rights in Cameroon. The first speaker is Professor MacCormick for 2 minutes.
Thank you, Mr. President. I cannot myself claim intimate familiarity with circumstances in Cameroon, but I and other colleagues in this House have been approached by friends and acquaintances whom we trust in non-governmental organizations, and noticeably the International Federation for Christian Action Against Torture, drawing to our attention matters of the gravest concern which merit the attention of the institutions of the Union and most particularly of this Parliament. We have well-attested reports of discovery of 2,000 mass graves, of the arrest of senior officers of the gendarmerie, of inquiries into an organization known as the Operational Command, and generally matters of real concern. It has been put to us that what is required is, first of all, an independent commission of inquiry to shed light on human rights violations, acts of torture, disappearances, and extrajudicial executions. A commitment to protecting adequately human rights defenders and local organizations working on this issue, and the appointment of some special rapporteur on extrajudicial, summary and arbitrary executions, and the working group on forced or involuntary disappearances being invited as soon as possible to inquire into matters in Cameroon. By coincidence, today's Le Monde has a special supplement on Cameroon, the opening sentence of which tells us that all the evils of Africa are to be found in Cameroon, and yet also all the reasons for hope for better. I think that what has been revealed to us here suggests that both of these propositions are true, both the reasons for hope and the present evils. Also this week in Le Monde, in relation to General Osares, we have been reminded that torture, disappearance, and evil-doing, the use of humans as means and not as ends in themselves, has been something which has scarred the history of our own continent all too much, both during the war of 1939 to 1945 and after it. We are not in a position to hold ourselves out as being somehow superior beings, but we can, as concerned human beings, share the concern of our fellows in Cameroon who are raising these points and members of international non-governmental human rights organizations which have been drawing it to our attention. I strongly commend this resolution to the House and hope it will be carried unanimously this evening.
Thank you, Professor MacCormick. Next speaker, Mr. Van Hekke, also 2 minutes on.
We now come, that's the end of the urgencies, we now come to the report by Mr. Lelelo. Professor MacCormick.
I'm not sure, President, if it's too late to raise this point, but I think that it is simply a point of translation, given that Italian would be the original version of the Di Lello report. Throughout the text, the word execution is used, meaning, of course, execution simply in the sense of carrying out a penalty. But in relation to criminal matters, in ordinary English, execution has a very particular meaning, and one which attracts considerable hostility in this House and goes against our view on human rights. I think myself that an equally good English translation of the Italian would be implementation rather than execution, and I think it would be wise to use the word implementation rather than execution throughout.
I think, Professor, you make a very valid point, and I think we will ask the services to have a look at the original Italian text to make sure that there is no misunderstanding on that point. Thank you very much for raising it. Can I therefore put the report with no amendment by roll call to the vote?
Merci, Monsieur Newton. Monsieur MacCormick.
Thank you, Mr. Newton-Dunn. Mr. MacCormick.
Madam President, Mr. Newton-Dunn is perfectly correct when he draws attention to Rule 2, but what he forgets is that in the elections that took place in 1999, they took place under proportional representation. No elector voted for Mr. Newton-Dunn, or indeed for me or for Chris Heaton-Harris. They voted for a party list. And Mr. Newton-Dunn represented himself as fully in support of the Conservative Party, of its leader and its European policy. He has now completely abrogated that position, and he is therefore denying the democratic rights of the voters of the East Midlands, over 40% of whom voted Conservative. I call on Mr. Newton-Dunn to resign.
Bon, Monsieur Elmer, ce débat britannique est certainement très récréatif, mais nous avons une communication extrêmement importante de la Commission sur la cohésion économique et sociale. Alors j'ai encore Monsieur Cunha, très brièvement.
Muito brevemente, era
Monsieur
MacCormick. Mr. MacCormick.
Madam President, that you had called me to speak a moment ago when Mr. Helmer, in fact, rose. I apologize if that is not the case. I thought it was. Thank you. It is actually the case. It is actually the case, Madam President, that in the United Kingdom electoral system, although it's a list system, the names of those on the list appear in the order in which electors are invited to vote for them. I therefore think that it is the case that we are here as individuals as well as representing a political position. I think that's very, very important. And I think it should be known that the United Kingdom Conservative Party was among those parties that voted for the provision that names should be on the ballot, not off the ballot.
Merci, Madame Torres Marques.
Thank you, Mrs. Torres Marques.
Obrigada.